Good morning and welcome to the June edition of Bracewell's Environmental Essentials webinar series. I'm Whit Swift, a partner in the firm's Austin office and a member of the firm's Environment, Land, and Resources team. My practice involves primarily air permitting and compliance work focused in Texas, and today I'll be speaking with you about three topics that all relate to air permitting here in Texas. The three are essentially unrelated to one another, but they're all issues that I've been working on or tracking over the first half of this year. And all three are broadly applicable enough that I thought they'd make good content for the webinar series. Given the time limit we have set for these webinars, we won't go into great detail on any of the three topics, but I hope to give you at least enough information so you know what's going on and can assess how it might impact your Texas operations. And my contact information is there on the last slide, so you can reach out to me directly if you have any follow-up questions or want additional information. The three topics that we will cover this morning are, first, TCEQ Air Permits and the authorization of shakedown or commissioning emissions. Second, what we've seen from the TCEQ Commissioners as far as their decisions relating to whether an interested member of the public has standing to participate in a contested case hearing on an air permit application. And last, I'll review what we've seen in a number of recent EPA orders on Texas Title V permits and what changes EPA is seeking in those Title V permits and how it may impact other permit holders. On to the first topic. What we're talking about here is whether and how the TCEQ addresses emissions during the shakedown or commissioning phase in Texas pre-construction or NSR air permits. The shakedown period is that time period before the start of normal operations where the permit holder conducts initial operational testing and tuning to ensure the safe, efficient, and reliable operation of the unit. That time period toward the end of the construction phase where you're running a unit to test it out, clean it, make sure everything's working correctly, and get any emissions control devices and monitoring systems up and running properly. I've been working with a client on this issue and the permitting of these emissions over the past couple of months. TCEQ permits have often been silent on the topic, not explicitly addressing commissioning or shakedown emissions at all. And more recently, TCEQ has been asking applicants about these emissions during this phase and wants to address them in the permit to get them explicitly authorized. And while the TCEQ told us that this wasn't a policy shift, the Air Permits Division has at least acknowledged that it has been inconsistent in its approach to these emissions in the past. And the challenge here is that, at least for certain kinds of sources, this shakedown period includes periods of operation where the control device is not yet operational. So emissions can be high, and in some cases higher than the MSS permit limits that were included or established for routine MSS activities, those that are expected to occur once the unit starts normal operations. And the TCEQ's interest in addressing these shakedown emissions in the permit can raise some real challenges, I think, depending on the nature of the source. In our case, the agency was initially willing to exempt these emissions from concentration limits in the permit, no question, but they did get stuck on the issue of the pound per hour limits in the MERT. And that raises hard questions. Can those emissions meet the MERT pound per hour limit, either for normal operations or more likely MSS? And if not, do we need to establish separate pound per hour emission limits for the shakedown or commissioning period? And if the TCEQ has a pound per hour limit, then it only makes sense that it's going to want to run modeling on those numbers. And depending on the source and the level of emissions during this commissioning phase, that could be a real challenge or even a non-starter as far as demonstrating that emissions during that period wouldn't cause or contribute to, for example, an exceedance of a short-term NAAQS. And this is all for emissions that arguably take place only during that construction phase, not during the operation of the unit, and are only temporary. For this particular project, we appear to have ended up in a good place, and as the draft permit sits now, do not have MERT limits that apply during the shakedown or commissioning period. But that is not what the TCEQ was initially seeking. For some types of sources, this may not be a big concern, but for others, it may present real challenges. And I believe it's something to be on the lookout for, particularly if you're talking about large emission units where the shakedown phase will involve periods of operation without those emissions controls being fully operational. Transitioning to our second topic this morning, let's discuss project opposition and contested case hearings. Contested case hearings are unique to Texas and are essentially a pre-permit issuance challenge, an appeal of the draft permit prepared by TCEQ staff before a State Office of Administrative Hearings administrative law judge, and this challenge all takes place before the permit can be issued. In this forum, applicants are typically successful, but time is the key concern. It can add a year or more to the permit timeline, and then also when you can start construction on a project. So issues related to contested case hearings and the impact that they can have on permit issuance date get a lot of attention. Now, in August of last year, the 3 TCEQ commissioners issued a decision related to standing on an air permit that put those of us who follow these issues on high alert. A person or organization that wants to challenge a permit in a contested case hearing must have standing to participate in that hearing. And it is the TCEQ commissioners that decide whether or not a requester has standing. And they determine that based on whether the person or association or group that want to challenge the permit have a personal justiciable interest in the application and the draft permit. The requester must have raised concerns that are relevant and material to the draft permit, and the requester must be affected differently from members of the general public. Now, this issue of being affected differently than members of the general public is typically determined by the requester's proximity to the facility that's being permitted. And again, often requesters aren't just individuals, but organizations or groups. And when the request is made by an organization like the Sierra Club, the organization must identify in its request an individual member who will qualify for standing on their own. So in August, the TCEQ commissioners were faced with making a decision as to whether or not to grant a hearing request that was filed on an application for an LNG terminal proposed to be sited in Port Arthur. And the commission surprised a lot of people by not denying the hearing request of the Port Arthur Community Action Network. The group's claim to standing hinged on the claim of an individual, the head of the organization, who lived approximately 4 miles away from the property boundary and 5 miles away from the proposed emissions sources. He also claimed that he frequently visited locations much closer to the proposed site for recreational purposes. Now, there's no bright line that the commission uses, and they've reiterated this a number of times, for how close someone must live to a site in order to have standing on an air permit hearing or in an air permit hearing. But in this case, based on what we've seen over past years, I would have expected the TCEQ to deny the hearing request. But here, the commissioners, in a 2-to-1 split vote, decided to send the issue of whether the requester was an affected person over to the State Office of Administrative Hearings for a determination. So they did not grant the hearing request, but they also did not deny the hearing request either. And in that case, the SOA judge subsequently determined that the requester and the group did have standing. So by referring the decision of whether the requester had standing over to the State Office of Administrative Hearings, rather than just denying the hearing request outright at an agenda meeting, the question was, are the commissioners here signaling perhaps a wider opening for project opponents to have standing to challenge air permits? And I have been following the commissioners' agenda meetings and their determinations related to air permit hearing requests since that time. And I think, following those developments, it's clear to say that this was not some kind of sea change as far as granting hearing requests on air permit applications. The commissioners have denied hearing the hearing requests on air permits that have come before them since that time, other than a few for concrete batch plants where the determination of standing is dictated by statute and is strictly based on distance, whether or not the person lives close enough to the site. But this one case, the LNG case in Port Arthur, was an example where that requester was represented by sophisticated NGOs, made the right claims in their hearing request, and had read the application closely enough to discuss the modeled impacts at their residents. They were seeking to challenge a project that's a new major source and is also located in Port Arthur, which is an environmental justice hotbed, of course. And again, in that case, the requester's 4-mile distance and recreational interests were strong enough to make it through the TCEQ commissioners and ultimately earn the right for that hearing requester to participate in a contested case hearing. So I don't think that decision signaled a new open door for getting a hearing request granted on an air permit application, but I do think it is something that applicants should be aware of as far as the potential for the commission to make a similar decision in a case where the facts align or at least are similar to those that led to their decision to refer the issue over to SOA in the Port Arthur LNG case. And that's something to take into account and factor that risk of a hearing into project timelines and into strategic permitting decisions. And again, it's if someone has a right to a hearing, while that's unlikely, very unlikely to result in the permit not being issued, it can certainly slow down the permitting process absent some form of settlement that'll make the hearing go away. Now let's transition to our last topic, which relates to EPA's recent orders on Texas Title V permit petitions. Now, our first two topics related to NSR permitting issues, but this third one relates to Title V operating permits, which are, of course, separate permits in our two-permit system here in Texas. As noted in the green box, EPA can object to a state-issued Title V permit if EPA determines that the permit does not comply with the requirements of the Federal Clean Air Act. Now, I'll give a quick review of the Title V public participation process to sort of tee up this discussion. First, when the TCEQ has prepared a draft Title V permit, it sends that draft permit to EPA Region 6, and it is deemed a proposed permit. That starts a 45-day review period for EPA, and if EPA objects to the issuance of the permit, then the state must address EPA's objection before the permit can be issued. Now, if EPA Region 6 does not object during the 45-day review period and the TCEQ goes ahead and issues the Title V permit, a member of the public can petition EPA requesting that EPA think again about this and requesting that EPA object to the permit, even though EPA Region 6 passed on that decision in the first go-round. Now, that petition sent to EPA must be based on comments that were made during timely comments filed and made during the public comment period on the draft permit and application. The decision about whether to object to an issued Title V permit is made by the EPA administrator, and it is the EPA administrator who signs the orders that either grant or deny a petition to object to a Title V permit. And when EPA grants the petition and objects to the permit, the TCEQ must respond to that objection either by providing a better explanation to address EPA's concerns in the permit record, or more commonly by making changes to the permit itself. So again, I think one thing to remember here is that when it comes to Title V permits, EPA is not merely a commenter, but rather when it finds that an aspect of the permit does not meet Federal Clean Air Act requirements, the TCEQ must address that objection. So EPA has now issued 8 orders relating to Texas Title V permits over the second half of last year and the first half of this year. These orders are all available on a page that on the EPA's website that tracks Title V petitions and EPA's responses. You should be able to find it pretty easily if you want to track those down. If you can't find it or want one of these documents in particular, please just let me know. And here, almost all of the issues are not unique to these particular permits, and that's what I think is of interest to this issue for the rest of the regulated community in Texas. EPA has on multiple occasions used Title V permit objections to push for programmatic change to Texas Title V permits. And I think that these recent orders highlight, in one bucket, some issues that are going to be changed in all Title V permits in Texas over time. And second, issues which, while specific to that particular source and that particular permit, because of the way permits are written here in Texas, other sites' permits may have similar vulnerability, particularly depending on the underlying NSR permits that are incorporated into that Title V permit. Now, this slide has a list of what I view as the key issues where EPA has found that TCEQ Title V permits didn't comply with the requirements of the Clean Air Act. The first relates to gaps in monitoring or compliance demonstration. Now, Title V permits are not vehicles for establishing substantive new emission standards or control requirements. EPA has been talking about that since the beginning of the program. The idea is that this permit pulls together all of the applicable air quality requirements for a particular source. But while it primarily serves to bring all of those requirements into a single document, the Title V permitting process can be used to establish additional monitoring or compliance demonstration requirements when there's an underlying requirement, such as an emission limit in an NSR permit, and EPA finds that there is not sufficient monitoring in either the underlying NSR permit or the Title V permit itself to demonstrate compliance with that requirement. And EPA has on multiple occasions, not just in this most recent group of orders, found that monitoring requirements had to be added to a Texas Title V permit or the underlying NSR permit. Again, most commonly where it's found that there's a particular emission limit or control requirement in an incorporated NSR permit, and it deems that NSR permit has a gap as far as the compliance demonstration. The second topic relates to permits by rule, or PBRs. EPA has raised multiple concerns relating to PBRs and how they're incorporated into Texas Title V permits. Those issues cover both sort of how to determine which emission units at the site are authorized or have had changes authorized by a permit by rule, and then also, along with this sort of compliance demonstration theme, concerns about what compliance demonstration method is used to ensure that the unit is complying with the applicable requirements of that PBR. Texas permits for years had essentially a table at the back of the permit that just listed the particular sections of the PBR rule in Chapter 106 that had been claimed at the site without anything more specific as far as tying those sections to a particular emissions unit and talking about how that emissions unit is regulated by that PBR and how the owner or operator demonstrates compliance at that emissions unit with the applicable PBR requirement. And that's really what EPA is pushing for change on and what TCEQ has been doing. And those of you that have been through a Title V renewal recently may have already taken a step toward addressing this issue, whether or not you are facing an EPA objection. TCEQ really started taking material steps towards addressing these concerns with this PBR supplemental table, which I think has been around since 2020, maybe 2021, I think 2020. And now TCEQ just recently further revised that PBR supplemental table. And again, it's aimed at addressing those concerns that EPA has raised regarding PBR authorizations, and most specifically, I think, trying to beef up and enhance the compliance demonstration aspect for those PBR requirements, and spelling out how the owner or operator, how the permit holder is going to demonstrate compliance with the applicable PBR requirements. The TCEQ has tweaked this approach a couple of times, and again, in this last month, put out a revised version of the form specifically to address that PBR monitoring issue. And at least going forward, applications for initial permit issuance and renewals and revisions that have PBR updates will need to include that updated PBR supplemental table starting August 1st of this year. So that's one that was raised in a number of these objections. Some of these objections are old enough that the applicant had basically either addressed it before EPA got to issuing their order, or that they were on the way to getting it addressed, but they were issues that the Sierra Club or other parties had raised, and it's an issue that's coming for everybody. And I think, talking to folks that have gone through this, I think it's safe to say that it is a headache to get all of this straightened out and to provide the information that is necessary to complete the PBR supplemental table. But that is something that is on deck for everyone in Texas, because it's become part of the Title V permit process, originally triggered by EPA objections. The third issue is a simpler one, and it just relates to the applicability of federal rules. And it has come up where a Title V permit has generally referred to a particularly applicable NSPS or NESHAP requirement, such as with language like the sources at the site will comply with the applicable requirements of NSPS subpart quad OA. A general kind of one-line applicability determination in the permit. And EPA has found this insufficient and is requiring the TCEQ to make unit-specific applicability determinations in Texas Title V permits. Now, permits for most rules have those kind of detailed applicability breakdowns in those giant tables that are parts of our permits. But there are certain rules where they have followed a more generic, high-level reference approach, and it's clear that won't fly with EPA. So that's another area where permits will have to change. The fourth issue relates back to these incorporated NSR permits, and it's another one where the vulnerability of your specific Title V permit to an objection on this point depends on the language of the underlying incorporated NSR permits. But where an incorporated NSR permit references an emissions calculation method, for example, that was included in the permit application, EPA has found this sort of a general reference to compliance with the calculate or use the calculation method specified in the application. They've found that to be insufficient, too vague, and they've directed the TCEQ either to, one, provide a specific reference to where in the permit record that information is found, such as the date of submittal and the page number where the calculation method was specified in an application document, or two, to take some step that would lift it and bring it directly onto the face of the permit. The last issue, and an interesting one, relates to flare compliance. And I saw this in one particular EPA order. And in that one, the petitioners were successful in getting EPA to find that a general reference in the NSR permit to 40 CFR 60.18, the NSPS flare operation provision, was not sufficient for demonstrating compliance with the requirement that the flare achieve 98% destruction removal efficiency. Now, in that particular case, it ended up not having any implications for the permit holder because after the date that the petition had been filed, the permit holder and the units in question had become subject to a federal MACT standard in 40 CFR Part 63 that had a beefed up flare monitoring requirement. So EPA found that while the general reference to 60.18 was not adequate, there were no changes necessary to that particular permit because the flare in question was subject to more stringent and thorough flare monitoring requirements under that MACT standard. But again, this could be a vulnerability for other sites' permits, depending on what rules they're subject to and what requirements are established in the terms of the NSR permit for monitoring the flare. So moving to the last slide, what are the takeaways here? First, it's obvious that these EPA objections highlight issues that are found in many other Title V permits here in Texas. For some, like PBRs, everyone's going to deal with them at some point. But for others, whether you end up facing it might just depend on whether or not your site becomes a focus of the sophisticated NGOs that have filed these, that have targeted specific sites and have filed these petitions. Whether Sierra Club, Environmental Integrity Project, others, if those groups don't focus on your site or focus on your permit, these issues may not arise. But there is a sign that the agency is at least doing some proactive steps to try to strengthen permits and maybe remove some of this vulnerability. Some clients have had the Air Permits Division approach them requesting, for example, to establish additional monitoring or compliance demonstration requirements during the Title V renewal stage based on the review of the permit and seeing what they view as a potential gap, again, to eliminate a potential ground for objection. So this is one where, again, a lot of these issues you may not see until ever, frankly, if your site isn't a focus or a target of these groups. But there are avenues in which these are going to creep into other permits, even if you don't draw the ire of Sierra Club or EIP. Now, in theory, the TCEQ has got a relatively short time frame for responding to these objections and fixing the permits or the permit record. And at least under the program established under the Clean Air Act, EPA could actually take over and issue a federal Title V permit for the site if the state doesn't act. Not surprisingly, the experience here is that this is not happening and that EPA does not want to become the Title V permitting authority for those sources. And EPA has been giving the TCEQ and the permit holder a longer time frame to address those issues, at least where EPA is comfortable that the TCEQ and the permit holder are making progress. And finally, one last point, and this is one that illustrates why I think it's important to stay on top of these issues. All of these recent EPA orders have come at the petition stage when EPA is issuing an order that relates to a Title V permit that was already issued by the TCEQ. Those orders, while it directs TCEQ and it puts them on a path of fixing the issue in the permit, it doesn't do anything to the validity of the issued permit. Now, as we discussed kind of at the beginning of this, EPA does have an earlier opportunity to object at the proposed permit stage. And if the EPA regional office files an objection at that stage, it will delay the permit issuance until the objection is addressed. Now, for permit renewals and minor revisions, that likely won't be a big deal. Typically folks aren't in a hurry to get their Title V permit renewed. But remember that in the case of a significant Title V permit revision, the permit holder can't start operating the change until the revised Title V permit has been issued. So I can see some risk here. Say if you've got a significant revision to your Title V permit that you need to have issued quickly in order to flip the switch on a big new project that triggered PSD or non-attainment new source review. And EPA issues an objection at the proposed permit stage. Again, recently that hasn't been happening, and these orders were all issued after the permit had been issued. But say they do issue an objection at the proposed permit stage. If you're a permit applicant and you need that revision quickly so you can flip the switch and start operating a new project, that objection on a proposed permit could be a real problem. So that, in my view, is a reason, at least in certain circumstances, to be more proactive in evaluating these issues and evaluating your risk of objection and what you might be able to do to avoid an objection. And at the very least, not to wait till late in the game to file the application for Title V permit revision. So hopefully you're not, if you do deal with an objection at the proposed permit stage, it's not at a crisis point for you as far as how soon you need that permit to be issued. All right, that's all I have for you this morning. Thank you very much for joining me. And again, if you have any questions, please feel free to reach out. My contact information is here on the slide. And also, before I sign off, let me put in a plug for my colleague Daniel Pope's Environmental Law Monitor podcast series, which you can find on all the finest podcast services, and let you know that we have an upcoming podcast plan to discuss another Texas air issue. This one relates to developments on the TCEQ MECT program, the NOx cap and trade program that applies in the Houston, Galveston, Brazoria ozone non-attainment area. And we'll have a special outside guest speaker on that one. So please be on the lookout for that podcast episode if you'd like to learn more.